Hello and welcome to the latest legal update from the Solicitors Group TSG Legal TV channel. My name is Paul Butt and today I'll be discussing a few recent developments with regard to the operation of break clauses in commercial leases. Now I'm sure we're all aware that when we're dealing with the drafting of a commercial lease, the drafting of a break clause, we need to consider what preconditions there are with regard to its exercise. I'm sure again we're well aware that if the lease says you can only exercise the break if you fully complied with the terms of the lease, that really does mean full compliance. So even a very minor breach that doesn't affect the landlord at all, doesn't affect the value of the property, is going to mean that you can't exercise the break clause. What recent cases show is there are other issues to think about when drafting the break clause, when dealing with the preconditions to the valid service of the break notice. And the first case that I want to deal with is a case called Quirk Co. Investments against Asprey Transport in the High Court in 2011. Two issues that arose in this case. Basically, the tenant was under an obligation to reimburse the landlord for the insurance premiums incurred by the landlord in insuring the building. It wasn't the kind of lease whereby the tenant actually affected the insurance. The landlord was affecting the insurance, sending the bill to the tenant. The tenant had to reimburse the landlord. In fact, what the landlord generally did was send the invoice through that he got from the insurers to the tenant, requiring the tenant to pay that direct, saving the landlord having to pay the money out of its own pocket and then claim reimbursement. Anyway, we had the exercise of the break clause. Landlord sends in the reminder for the insurance for the next 12 months, £3,600 odd, and the tenant queried this and said, well look, I'm not going to be there for the next 12 months, only there for a few weeks because of the break. I shouldn't be required to pay the insurance for the full 12 months. Landlord disagreed. Landlord took the view that the payment was due prior to the exercise of the break, therefore under the terms of the conditions attached to the break clause, he was entitled to the full year's insurance. Basically, the court would have agreed with the landlord. The only snag was the wording of the lease. The lease said that the tenant had to reimburse the landlord for payment of the insurance. Please, landlord, said the tenant, prove that you've paid this insurance premium. Unfortunately, what had happened is that the landlord had allegedly sent a cheque into the insurers and it had got lost in the post. So no payment by the landlord, and the obligation of the tenant was to reimburse the landlord. And you can't reimburse somebody when they haven't paid it themselves in the first place. So therefore the tenant was okay. The tenant had actually complied with the lease terms as far as they went. No worry about not reimbursing, purely on the look that the landlord had never paid it in the first place. Of course, had the landlord paid it, then basically the court was saying, yes, the tenant should have paid the full amount, even though they're only there a few months. Tenant was also querying the actual rental payments it had made. It had paid for a full quarter's rent in advance, but again was only there for a very short period of that quarter. Was the tenant entitled to reimbursement of these rental payments that it had made? No, said the judge. Nothing in the lease that provided for reimbursement, nothing in the Apportionment Act or at common law that provided for reimbursement. Maybe a lesson there that when we're drafting the lease, we ought to put a provision in for reimbursement of rent paid for periods after the break date. Or maybe we ought to tie in the break date to the rental payment dates. So that is the Quirk Co. case. Slightly later in 2011, we had a case called Aberset Industrial Estates against Merrill, M-E-R-O-L Limited, which follows on from Quirk Co., dealing with similar kind of situations. First issue, first problem, was again payment of rent in advance. Definitely the rent had to be paid in advance for the full period. No doubt about that. the court is saying, not just for the period up until the break date. It had to be paid for the full period that was due on that particular rental payment date. Full quarter, full half year, whatever it might be. So again, warnings there for tenants, warning there for tenants' advisors dealing with the drafting of that lease. But how are these payments going to be made? Tenant in this case has sent payment by cheque. Landlord hung on to the cheque for a few weeks and then sent it back saying, we don't accept cheques. Was payment validly made by cheque? And basically the judge went back to the basic common law position. The basic common law rule is that you have to pay your debts by legal tender, legal currency, unless there's an agreement to the contrary. Cash, unless there's an agreement to a contrary or a course of dealing between the parties. Fortunately, in the particular case, the landlord had previously accepted payments by cheque on several occasions throughout the period of the lease. Because the landlord had previously accepted cheques, it was now too late to insist on legal tender. But it's something bearing in mind when very often in leases these days there's a requirement that the rent is paid by some kind of direct credit transfer. There's nothing in the lease that allows payment by cheque. Then a tenant may be making a payment by cheque, would find that that is not valid payment. The landlord can reject the payment, refuse the payment. If the lease requires payment by direct credit transfer, that's the sensible way to make it, by making a direct payment into the bank account. The other issue that arose in the Aberset case was an issue with regard to the payment of interest on late payments of rent. Very common situation that you have a commercial lease is that if you don't make rental and other payments on the due date, then you pay interest at the specified rate, 4-5% above base. Sometimes you have a few days grace before the interest kicks in. Now, under this particular lease, the tenant had been late in paying the rent on several occasions throughout the previous 5-year period. The landlord had never claimed the interest that was due under the terms of the lease. Tenant had never paid it. When it claimed to exercising the break clause, the landlord said, no, you can't exercise the break clause. You haven't complied with the preconditions. You've not paid in full all the rent and other sums that are due under the lease. You haven't paid in full all this interest. I say all this interest, I think it amounted altogether to just over £100. Because what the landlord had done, he had gone back over the period of the lease, previous 5 years, and sort of worked out how much interest the tenant was liable to pay. Tenant was a couple of weeks late there, a month late there, and worked out the interest in each individual payment and said, look, this is the amount you should have paid. Obviously all this came about when it was too late for the tenant to pay it. Tenant should have paid it before the exercise of the break clause. So was this the landlord could actually insist on? Could the landlord insist on payment of this interest? Tenant said, well, you never claimed it. Judge said, well, the lease doesn't require it to be claimed. The lease says quite clearly, if you're late in paying, you pay interest. And the tenant said, well, how am I supposed to work out how much interest is payable? I think the judge's attitude to that was, well, the landlord managed to do it, why couldn't you? The landlord had gone through the lease and worked out the interest. There's no reason why the tenant shouldn't have done the same. So again, because the tenant hadn't paid that interest, it hadn't fully complied with the provisions of the break notice. For the sake of £100 and odd, it found itself unable to terminate that lease, that the break clause had not been validly executed. So, from a point of view of practitioners, I think there are two issues there to be careful of. We've mentioned the issue of how do we make payment, but also it must mean that we ought to get the client, the tenant client or the landlord client, to search its records throughout the period of the lease. Was some interest due on late payments? Were there any late payments? How late? How much the interest? If we're acting for the tenant, make sure that those interest payments are made before the relevant date set out in the break notice. And from a landlord's point of view, check whether they've been paid. If they haven't been paid, then that notice has not been validly served. All the preconditions have not been complied with. So lots of issues there for solicitors acting for both landlord and tenant to consider.